The next presentation, as I mentioned earlier, is by Professor Vicki Jackson, and she will be addressing us on the separation of powers in the global north and accommodating an all-constituent to the 21st century state, law and politics. 20 minutes.
Okay, thank you very much. I'm going to stand because my back hurts me. I'm so old, my back hurts me if I sit for too long, so I hope you won't mind. Let me just mention one little statistic that supports the concern that David started us out with and that we discussed a little yesterday about legislative power and legislative legitimacy. The Gallup organization has been running the same poll since the 1970s on confidence in institutions. They asked the public, how much confidence do you have in the military, in small business, in doctors, in banks, in the police, in churches, and so forth. 20 categories. In 2014, and I'm telling you this because this was not a sport, this is a consistent pattern, although shocking where it ended up, Congress was the lowest. Let me give you an idea of magnitudes. The military, 79% had a great deal or a lot of confidence in it. The police, notwithstanding all the problems we've read about, 43%. The presidency and the Supreme Court, 30% confidence. Banks, which you know how much people love, 26%. Congress, 7%. Military, 79%. Congress, 7%. I think constitutionalists ought to be worried. All right, I have three themes in my presentation. The first is about change, mostly in doctrine, from the founding, about ideas concerning the relationship between legislative and executive power at the national level. Originally, the legislature was seen as the most powerful branch, the branch most to be worried about, exercising tyrannical powers. That has certainly changed. Second theme is the relationship between the powers of the federal courts, particularly the Supreme Court, and the administrative judiciary and the apparatus for the execution of the laws. Third, I hope to have time to address the question, what difference do these doctrinal changes make? What is really influencing the diffusion of power, the sharing of power, or the centralization of power in the U.S. constitutional system? And I think you will see some similarities in the points that have been made with other systems. All right, on the first question, overview, the U.S. Supreme Court's doctrine provides very little in the way of support for the primacy of Congress as lawmaker. It provides an enormous amount of detail concerning the appointment and removal of officials who carry out the law. I will try to give you a little flavor of each of these. All right, beginning in the 19th century, the Supreme Court developed a doctrine called non-delegation. Many of you may have similar doctrines. The idea is if the legislature gives power to an executive department or an agency to effectuate the law, there needs to be guidance from the legislature about the direction of the lawmaking. And this doctrine resulted in the invalidation of some major statutes during the New Deal period, 1935, and has not been relied on since. 80 years with very, very broad delegations of power to regulate in the public interest being upheld. Case came down in March of this year suggesting that some of the justices may want to revitalize it, but not a very active story. Second story. We had in the United States the growth of what was often called the fourth branch, meaning administrative agencies that operated without the ability of the president directly to control it because they would be headed by independent tenure-guaranteed officers. Were these constitutional? And a number of separation of powers challenges began to be raised beginning in the first third of the 20th century. So 80, 90 years ago, over time. One of the responses that Congress developed to the need to have administrative agencies as law and society became more complex, as the need for regulation over a wider array of areas emerged, Congress would delegate rulemaking authority to administrative agencies, which could also enforce those rules that they made and could also adjudicate violations, combining the three. Congress would delegate rulemaking authority subject to the Congress or a part of Congress exercising what was called a legislative veto. These rules appeared in some 200 statutes when, in around 1983, the United States Supreme Court held this was unconstitutional. Congress could not reserve a power to veto rules made by an agency. The only way Congress could stop those rules was through a new law enacted with both houses of Congress agreeing and the president presentment and so forth. This was a very major decision. Very formalist. It said if Congress wants to act to affect the rights or status of those outside the legislative branch, it has to do so through the lawmaking process, bicameral passage of the law, presentment to the president. Now what's interesting is, notwithstanding this case, which is called Chadha, Congress has continued to provide for legislative vetoes in some 400 statutes since, and administrative agencies and departments typically comply with them, even though there will be no judicial enforcement. Why? Because Congress does hold the purse strings, holds the budget for their agencies. All right, third area I want to talk to you about, doctrine changing, and this is the area of appointments. From the Civil War period, when our Congress got into huge fights with the person who became president after Abraham Lincoln was assassinated, since the Civil War until 1920s or so, 70 years, there was a fight between the Congress and the president over whether the president could remove cabinet officers without the consent of the Senate if the law so provided. Senate has to confirm. Congress took the position, well, if the Senate has to confirm the president's nomination, then the Senate has to agree before the president can remove. Presidents consistently said, nope, not constitutional to limit our power. And in the 1920s, the Supreme Court agreed in a case called Myers. It was unclear, however, whether Myers was based on the idea of Congress having too much power, or whether it was based on the idea that the president had to be able to remove people in the executive branch when he wanted to. In a case in the 1930s that directly challenged independent officers of administrative agencies, that is, persons who the president could not remove when he wanted to, who had tenure for a specific term unless certain specific good causes could be shown, the Supreme Court upheld this kind of position, but in reasoning that was a little odd. It said, well, an administrative agency, like the Federal Trade Commission, has quasi-legislative and quasi-judicial functions. It's not purely executive, and therefore it's okay for Congress to impose this limit. I'm not going to try and justify that reasoning because it never made sense to me, but that's what the court said. This left unclear whether, for purely executive functions, the president's removal power could be limited. And we don't find the answer out to that until the 1980s. Before then, here's what else we find out. In the 1970s, the Supreme Court, in Buckley against Vallejo, said, Congress cannot itself choose people who are officers of the United States, who exercise significant authority under the laws of the United States. What does significant authority mean? It means acting to enforce the laws or acting to adjudicate violations. Anyone exercising those powers have to be appointed in one of the four textually specified ways: President with Senate confirmation, President alone, courts of law, or heads of departments. In a case called Bowser, next question, can an officer who is removable by Congress execute the laws? Answer, no. Now what's really interesting in this case is the law in question was one designed to reduce the federal budget, and to do so in an automatic way so that members of Congress didn't have to vote on the budget reductions. One might have thought the big separation of powers problem here was the delegation of authority over the budget. What the court said was the law was unconstitutional because the officer charged with estimating the automatic budget cuts was the Comptroller General of the United States, who could be removed from his office by a concurrent resolution of both houses. In a case called Morrison, we finally get an answer to the question left open by the case in the 1930s about the scope of the authority of Congress to limit the president's power to remove purely executive officials. And that involved what in this conference's terms would have been called an accountability agency, the independent counsel who was established to investigate claims that the president, vice president, or high officers of the United States had engaged in criminal wrongdoing. The statute said the independent counsel would be appointed by the courts and could be removed only for very specific good cause by the Attorney General. Earlier cases had said a quintessential executive function is enforcing the criminal law, moving to enforce the criminal law. This was a quintessential executive function, but the court says the good cause limit on removing the independent counsel is constitutional. The court articulated a very flexible standard. The question didn't turn on whether it was an executive function or a quasi-legislative function. One asked, did the limitation on the power to remove seriously interfere with the president's ability to take care that the laws were faithfully executed? Answer, no. So people were a little surprised when, this is the last case I'm going to bore you with, in 2010, in a case called Free Enterprise System against the PCOAB, the court held unconstitutional provisions establishing essentially an independent agency within an independent agency. So the PCOB was established as to monitor the accounting firms that audited the big public companies in response to one of our many financial crises. The members of the PCOB could only be removed for good cause by the Securities and Exchange Commission. The Securities and Exchange Commission also had good cause limits on their removal. They were independent. And the Supreme Court, 5-4, said that the double layer of good cause provisions interfered with the president's ability to take care that the laws were faithfully enforced, returning to a very formalistic account. So no consistency in interpretive approach across these cases, but we do have a very complex set of rules that have developed in part as an accommodation to the growth of the administrative state. Now let me turn to my second point, which is about the courts. I have a much shorter story to tell you, although it's also, I think, quite important. As I've mentioned, these administrative agencies were often given both rule-making power, rule-enforcing power, and adjudicatory power to adjudicate disputes that arose. Challenges came up in the early part of the 20th century, arguing that the allocation of adjudicatory power to administrative judges was inconsistent with the Article 3 provision granting the judicial power to life-tenured, highly protected federal judges. In a case called Crowell against Benson, the Supreme Court upheld the authority of Congress to give administrative adjudicators final fact-finding authority, subject to two things. First, appellate review was available on the legal issues in the Article 3 courts, And second, in that case, the court said, but you cannot give administrative fact finders final authority over what the court called jurisdictional facts or facts on which constitutional rights depend. Over time, we know the more important part of this case was the permission to adjudicate. The exceptions for jurisdictional facts and facts on which constitutional law depend have not been used in subsequent case law. We have a massive administrative judiciary at the national level in the United States. There are more administrative judges operating in the federal departments and in the independent agencies than there are Article III judges. Again, an accommodation developed by Doctrine to the rise of an entirely unforeseen administrative judiciary. Now, let me come to my third question, because I think I have time to ask, what difference has the evolution of Doctrine made? The reason I'm asking this is there are a number of areas of separation of powers doctrine in the United States that when I look comparatively, I think we could really do better. We could have, for example, a requirement that legislation needs to be general. Germany has such a requirement with respect to legislation affecting fundamental rights. We don't. We don't. Congress can legislate about one particular matter and can do so in ways designed to affect pending cases subject to very, very, very loose limits. So we might be able to improve that. We might be able to rethink the Chadha decision, the one about the legislative veto. The Chadha facts weren't about rulemaking. They were about Congress saying these 6 people, 6 individuals who have been granted waivers of deportation have to be deported. One opinion in Chadha said, this is a problem of Congress exercising judicial functions, but that was not the opinion of the court. And many people think that having a legislative veto makes a certain amount of sense, given the need for very broad delegations of power. Okay, so there might be areas in which one could improve, but would it make a difference? And here I'm not sure. As David Landau mentioned earlier, some people now think in many countries, perhaps including France, that the key to avoiding concentrations of power lie less in the structures of government and more in the conditions for political competition. If you don't have a real competitive political environment, it can be very hard to sustain the idea of the separation of powers. This might lead us, as my colleague suggested, to thinking more about things that we associate with rights. For example, in the United States, there is a very rich, thick civil society. Thousands, hundreds and thousands of organizations. Their constitutional existence is protected by freedom of association in the First Amendment. So we might think of something we thought of as a right as being fundamental to maintaining the diffusion of power that we heard about yesterday in the corporate sphere as being an important element of separation of powers going forward. On the other hand, in the United States, the right of freedom of speech has been associated with the freedom to spend money on political campaigns, resulting in the invalidation of many campaign finance laws. So can interpretation of rights obstruct the ability to maintain a competitive political environment? Something to think about. Second point in terms of what difference it makes. I think the empirical issues that Professor Landau and others have been directing us towards are very difficult to find out about ahead of time. Courts have to make decisions going forward. We have to make decisions going forward. And the more I learn, the more I think that a little bit of humility about our ability to predict future effects might be called for. So this brings me to another current controversy. I think I have time to sketch it for you. The Supreme Court in 2014, just last year, decided a case called Noel Canning against the Nlrb. The issue in the case was whether the president had acted constitutionally in appointing members of this board during what he claimed was a congressional recess. The Supreme Court ruled against the president. He won on 2 issues relating to the recess clause. He lost on another. So the result in the case was that the employer was able to vacate the order because the board had not been properly constituted. A scholar at Columbia named Jamal Green wrote an article in the Harvard Law Review saying, the U.S. Supreme Court, in separation of powers disputes like this one, should act more like a constitutional court. We should allow legislative standing because it's better to get the issue settled. And if we rely on waiting for an individual with injury to bring it before the court, you may have years of uncertainty. And indeed, there had been years where there were different positions taken on this. And I worry about this. And here's why. First of all, the U.S. Supreme Court is not constituted as a constitutional court. We have life tenure. Our justices can serve for 40 or 50 years. We have no regular basis of getting democratic inputs through the appointment of new justices. Second, if we decide separation of powers disputes immediately, there's no opportunity for the history of working the Constitution. Carl Llewellyn had a great article called The Working Constitution, which was about how what the Constitution was could only be determined by watching how it was worked by the participants. If you review it judicially right away, you don't get the benefit of seeing how things get worked out over time, and that historical practice has played an important role in many of the separation of powers cases. Third, in recent years, the U.S. Supreme Court does not have people appointed to it who have served in elective office, who have served in legislatures, who have the experience of knowing how those systems work, which might mean that they'd make more mistakes. And finally, the U.S. Supreme Court is already extremely empowered. Do we want to empower it further by expanding the cases it can take into this area? I'm not sure. In my last minute, I'm going to add to Professor Landau's questions from this morning. Professor Landau said an important question is whether the new fourth branch institutions or the courts can control executive power. But I think there's another question, and that is, can constitutions or constitutional doctrines reinvigorate the legislatures as a source of power and checks in 21st century constitutionalism? Thank you.
The University of Johannesburg. Rethink, reinvent.